Hello everybody and welcome to this special webinar with John Stewart of the Residential Landlords Association, soon to be the National Residential Landlords Association, where we're going to be talking about what landlords need to know about coronavirus. Just a few housekeeping issues. If you're listening to the live webinar, because this is being recorded, so if you're listening on the recording, you obviously can't ask questions, but if you're on the live webinar, there is a Q&A box at the top and you can ask questions there, and I will put them to John at various stages. We will try and answer as many questions as we can. We probably won't be able to answer all of them, but we'll do our best. This presentation has been loaded up as a download, so you can download it. If you look, should be a handouts link there, so you should be able to download that. So, John, over to you.
Hi, Tessa, and good morning, everyone. I think the first thing we need to say is there has been a lack of definitive guidance from the government, particularly round about the rental sector. So what we try to do in our advice to landlords is marry up current obligations with the health and isolation guidance that the government have issued and a bit of common sense. So some areas where we know what the government has said and what landlords expect to do, other areas we are giving our best advice. So let's look at that best advice at the moment. A quick overview of what we want to run through this morning. We'll start off looking at the health advice, and I don't want to spend too much time on that. It is all out there and widely available from the government and the NHS. We'll then look at some of the management issues, and I can see there's questions coming in already round about property management issues, so we'll try and address some of those. We'll then look at some finance issues, rent, benefits, support for landlords, and then we will take a look at the changes that the government's making to the possession. So to start with the health overview, basically it's follow the government and NHS guidance. There is hygiene guidance out there which applies to everyone. There is social distancing guidance that applies to everyone. There's self-isolation for symptomatic people, people showing signs of COVID-19, their household, and also high-risk groups, for example, if you have returned from a country like Italy in particular. And then there is new last week, there was the shielding advice. That's for the 1.5 million vulnerable people who've been identified who are being asked to stay in their homes with absolutely minimal contact with people for 12 weeks. But as I say, there is guidance available on government websites. I don't want to spend too much time on the health advice. In practical terms for landlords, what that really means is avoid visiting your properties if at all possible. It does mean signposting tenants to government advice, principally by email or text if you can. It means getting official advice notices displayed in HMOs, although with the new effective lockdown advice, if you haven't done that already, we would now suggest that you email those notices to your tenants. Consider the availability of soap and hand sanitizer in common areas of HMOs in particular. That might be a bit difficult with supplies in the shops at the moment. And then consider what support you might be able to give to those vulnerable tenants, either in helping them with their isolation period of 14 weeks, and that might be signposting them to support services, social services and the like, or potentially, if you are able to, perhaps collecting, shopping and the like for them.
Okay, shall I just chip in here quickly, John, and say that there are some posters that you can print off and put in your properties, which are downloadable from the RLA special coronavirus section. And we do also link to that on the Landlord Law site, where we have a special coronavirus help page. Can I also say very quickly to the people who've just come in, you can download the presentation as a handout. And if you missed the first part, it is being recorded and you should be able to listen to it again fairly soon after we finish. John.
Yep. And now we'll get into some of the issues that I think a lot of the questions are going to be about, and that's really about property management. We saw the advice last night from the Prime Minister, a very powerful statement about limiting travel, limiting where you can go to all really but essential services. Quite clear that someone's home is essential. It's the way that most people will be able to abide by the government advice is by having a safe and secure home. And that is the priority at the moment. And likewise, the last thing we need is increasing homelessness in the midst of a public health crisis, which is why we've been supportive of the government's lines where they want landlords to do what they can to help tenants stay in properties. And we realise that can be difficult, particularly where landlords themselves are reliant on that rental income, or where you've had a history of arrears from a tenant or antisocial behaviour or worse, criminal behaviour. But broadly speaking, for most tenancies, landlords should be seeking a way to work with their tenants to keep them in the property. So an overview again of the property management section. We are asking people to keep in touch with tenants, obviously remotely if you can. Avoid unnecessary visits to your property. You will be the best judge of that. That will mean delaying non-essential repairs and maintenance. It will mean following social distancing advice for any necessary visits by you, by staff or contractors. It does mean having a contingency plan if you need to self-isolate yourself. If your property is managed, it means keeping in touch with your agent. And it does mean, unfortunately, keeping records. We all know how paper-based letting property has become, the need for evidence. So if you are missing essential checks, it's important to document the reasons, particularly if it's the tenant who is refusing access or because they're self-isolated. Do keep those records. So keeping in touch with tenants. Communication is going to be really important at this point, but you're going to want to do that as much as possible by email, telephone, video, or messaging services. Do let your tenants know you're aware that the coronavirus outbreak may have an impact on them, be that in their ability to work, to have income coming in, and on the services that you are able to provide as a landlord. Do, as far as possible, be sympathetic. I realise with some tenants that's not always easy, but we are, in the famous words of a former Conservative Prime Minister, all in this together. Do signpost people to government advice. Really important, again, if you are having to cut back on services or cleaning or the like, let your tenants know. Don't just leave them without a cleaner coming in and not knowing the reason why. So do warn tenants if you're having to put off the maintenance, repairs, cleaning services and the like. Really important in terms of the health advice, it's important that you ask your tenants to advise you and other tenants in the property, particularly in HMOs, if they become symptomatic of coronavirus and have to self-isolate. The advice now on how it is that whole households will have to self-isolate where a tenant becomes ill. In an HMO with shared facilities, that will mean that other tenants will need to know that they have been put at risk and they will need to follow the government guidance on isolation, which can be up to 14 days. And again, if you are having to put contingency plans in place, let your tenants know that when necessary, whether that's handing over management to an agent or a friend.
Would you like me to ask a couple of questions, John?
Well, yeah, let's see where we're going with the questions. That might head off some more.
We've had a question from Judy, which seems to match what you're talking about. She says, is it okay to continue to have cleaners or landlords going into HMOs where tenants are working from home? We are not aware of any showing CV symptoms yet. We also have a tenancy changeover due next week and need to get the room cleaned for the incoming tenant.
Yeah, cleaning is a difficult one. Ideally, if you can get your tenants to carry, and it is in one of the later slides, but ideally, if you can get your tenants to commit to doing the cleaning, either by paying them or agreeing a reduced rent, that would be better than having someone from outside coming into the property. In terms of turnover of properties, we expect that to be greatly reduced. But like I say, people do need homes. People are going to have to move over this period. We would consider that to be one of the essential services. And if that potentially requires a deep clean or the like, and that probably is a cautious and sensible measure at this time, then you may well want to look at getting professional cleaners in. You probably still can for things like that, but you will need to, again, have them following the social distancing rules, minimal contact, advise your other tenants when the cleaners are coming in, ask them to stay in their own rooms or take their one form of exercise at that time. And, it's all about information, communication, and as far as possible, sticking to government's health guidelines.
Okay, let's move on with the presentation.
Okay. So repair, maintenance, and inspections. Really essential work should be work that affects tenant safety or where the property may become uninhabitable. So, that's things like broken boilers, sanitation problems, water supply, power supply. If you have a leaking roof, for example, those sort of issues will need to be addressed and addressed as quickly as possible and where availability of tradespeople allow. There are questions around about licensing inspections, gas and electrical safety checks, smoke and CO detector checks, and this is where the government has been really disappointed. We have met with senior officials at MHCLG, with the Housing Minister, with Downing Street for over a week now, and we've been hammering home the fact that landlords need clear guidance, and as landlords need to know that enforcement is either going to be relaxed over this period, that councils are not going to take action, that these sort of things can be deferred, because a lot of these things realistically are not necessarily essential. Smoke and CO detector, tenants can potentially be checking themselves, perhaps over a video link, FaceTime or something. It is extremely unlikely a gas installation is going to become unsafe over a period of 2 to 3 months if it was signed off as safe the year before. Not impossible, but very unlikely. And licensing inspections, for goodness sake, if there's one thing that should be stopped now, is completely unnecessary either property inspections by the landlord linked to licensing conditions or inspections by the council themselves linked to licensing. But we're not getting clear guidance. So we then have to fall back on what is essential. So at the moment, and the lack of clear guidance over, particularly, I'd say, gas, electrical safety, these are probably still going to be carried out at the moment if you're new. You will still need tenant permission to enter the property, and tenants may not want anyone in the property because they are self-isolating or because of the risk of someone coming in to the property who may be ill and be unaware of it, or who should be self-isolating but needs the work and is continuing to work, because we all know the government has not provided support for self-employed, and many of these contractors are going to be self-employed. You should check that anyone coming to the property is not symptomatic. All you can do is ask the question and take that at face value. In the property, contractors should be following the social isolation hygiene advice. Again, if you can get a firm time, tell your tenants, tell them to stay in their rooms or to take their exercise at that time. And you'll get your contractors ensure they're washing their hands, washing down surfaces when they're finished. And again, keep records of all of this. If the tenant is refusing you access for a gas safety check, get that, if possible, in writing from the tenant and keep it. If you are getting contractor after contractor refusing to take on work and visit your property, keep those records. You may need them later on. However, I think it's unlikely that councils at the moment have the capacity to step up enforcement action. I think a bit like the courts saying, we are suspending cases because of social isolation rules and staffing issues. Councils are going to be in the same boat in terms of enforcement. But what it would be good would be to have firm and clear guidance from the government on that, and we've not got it yet.
So far as gas safety checks are concerned, the obligation for landlords is to make 3 documented attempts to gain access. Now, if the tenant totally reasonably sends the landlord an email saying we cannot allow this at this time, and that happens 3 times, then effectively the landlord is off the hook. So, you may want to tell your tenants that and say that you've got this legal obligation, but if they write and say that they refuse access, then that'll be the end of it.
Yeah.
3 times.
But again, that again, it's just at the height of stupidity, isn't it? Because that situation is unlikely to change over the period. Why does it need to be 3 times at the moment? Surely the government can simply say 1 refusal is enough at the moment. But we're just not getting that clarity of thinking or common sense, unfortunately.
Well, if you make 3 appointments and your tenant says no 3 times, then the landlord is off the hook, basically.
Yeah, but again, keep those records and keep the information.
Yeah.
And carry out the check as soon as practically possible afterwards, which, if we've a whole pile of deferred checks, means there's going to be a whole pile, a whole backlog. And again, there's going to be questions around about the availability of inspectors. We're trying to get 3 or 4 months worth of checks done in the first week when things return to normal.
Yeah, I mean, it may be an idea for landlords just to keep a management diary of what they're doing with the property, so that, because it's very easy with these changing times to forget what's happened before. So if you just keep a management diary on a date-by-date basis and say what you did, and perhaps also record your reasoning for things as well. We took the decision not to do an inspection on this day because of, and then if somebody comes to you later on, then at least you've got your reasons, and you've sort of like done a risk assessment and made a decision, and that's
absolutely and keeping a diary will be something to fill the long hours at home as well.
That's right. Yes.
But we'll pop on to other issues that might come up. Again, we've touched on this. You might have difficulty securing contractors, inspectors at this time. Well, one thing we would say is if you are offering a reduced service or where repairs are being put off and it's affecting the livability, although not the habitability of the property. Now, if the property is just a bit worse for the tenants over that period, you may want to consider reducing rent as a goodwill gesture. It will probably help build the relationship with the tenants over the period, and it's probably worthwhile considering if you can afford to do that. Again, back to the cleaning issue, you can ask your tenants to undertake, for example, the communal cleaning in HMOs, either for pay or rent reduction if you don't want to send cleaners in or your cleaners are refusing to visit properties at this time. But we do need clarity, as I say, on urgent, non-urgent legal obligations. We are calling for a deferral of these obligations or a non-enforcement, and we're calling for a delay to all new licensing schemes. I think there's 6 licensing schemes due to come in over the next 3 months that will all require paperwork, certification, potentially workmen coming into properties, inspectors coming into the properties, and we just think it's a nonsense, to be honest, to be pushing ahead with these schemes at this time.
We've got a question about the new electricity safety certification coming into force in July. Is that on a later slide?
It's sort of caught up in all of this. It's one of the issues, again, where we're asking the government to push that back at this time. Again, it just seems crazy to be creating a rush of inspections and potentially works to properties at a time when we're trying to prevent and minimise contact.
Yeah.
But at the moment, there's no clear guidance in that. It would be a very simple thing for the government to do.
Okay. Yes. Sorry, I've got some more questions, but I think they need to deal with in your finance section later on.
Okay. Well, we'll hurtle on then. A big issue and something we're getting lots of questions on in our advice team is round about the marketing of properties, voids, checking in, checking out, and the like. And one of the things we are going to see is fewer people looking to move. At this point, I think we are likely to see an increase in voids. That will have implications for landlords, both in terms of lost rent and council tax liability and the like. And we are, again, pressing the government for support there. If you are trying to market a property, then do consider video viewings. Visit the property on your own, particularly if it's an empty single let property. Bear in mind, though, if you are doing video viewings, they have to be fair and honest. You are covered by consumer protection regulations. You can't just sweep round the room and ignore the big damp patch. You can't, again, sort of hurtle across the big burn mark in the carpet or the like. These have to be honest and fair viewings. They are subject to consumer protection. If you omit something from that viewing, that could affect a tenant's decision in renting that property, then enforcement action could be taken. So video viewings are a good idea, but make sure they're thorough, make sure they're fair, make sure you're being honest with them. There will be issues with tenanted properties, if you, particularly HMO properties where it's a room vacancy rather than a property vacancy, but even where you have a single let, it may well be you have tenants in situ while you're trying to market that property. And unfortunately, in those situations, it's going to be very, very difficult to arrange viewings and the like. And absolutely one thing you can't do, even with an empty property, is have group viewings now. The gatherings are limited to 2 people. So anyone who does the open house type viewings and the like, that is absolutely out of the question now with the new rules that came in yesterday. But to be honest, the landlord should not be considering that anyway at any point really in the last 2 to 3 weeks. So you will have issues if you have tenanted properties. You may be able to get a video done of communal areas and the lettable room by agreeing a time when the tenant will be out the property, either shopping or doing their exercise. But if you've got someone self-isolating, it's going to become almost impossible. And unfortunately, that's just something landlords are going to have to accept and deal with. Inventories, checking in and checking out, again, are they absolutely essential at this time? It's something for landlords to consider. There will be people needing to move out of properties. There will be other people needing to move in. It's important for people to have a safe and secure home at this time. So, moving into a property is probably an essential bit of work. Is the check-in and check-out essential? More difficult to justify. It's sensible. So you might want to consider reducing the number of people you meet at that point. So perhaps bring one lead tenant who will agree things on behalf of others for the check-in and check-out. And likewise, perhaps, agreeing in an inventory remotely, a video inventory or the like. But a lot of this is common sense, and people will have to use their judgment. And again, you do have to follow the social distancing and hygiene rules. But if we can't get effective inventories, check-in and check-out, we might be seeing an increase in deposit disputes a little bit down the line. On the other hand, if tenants are struggling to pay the rent, then a number of these deposits are going to be retained in full to cover rent payments, I suspect. But just the whole problem at the moment is issues are being stored up for further down the line, and we'll see that in the possession process as well.
Okay, I'll just chip in and say we have had a lot of questions. I think probably it might be better if I just went through most of them at the end. Yeah. And I'll ask people, and I'll just go through them then. Yeah. There are quite a lot, and I think perhaps I don't really want to interrupt your flow.
Well, some of them are relevant to the section we can dive in, but hopefully quite a lot of them will get answered as we go through the
I think so, yes. So we have had quite a few questions, for example, about students wanting to leave early, stuff like that. But I mean, you will cover that.
Okay. Well, finance, obviously a big issue. Not all landlords are the greedy, wealthy, foreign holiday, expensive car-owning folk that are sometimes painted. So in this section, we'll look at issues around about rent and tenancies. We'll look at financial support available for tenants. We'll look at the mortgage holiday situation and we'll look at the limited support that is out there for landlords at the moment. So in terms of rent, this is probably the biggest issue, is rent going to be paid? And you do have to be proactive. Ask your tenants if they're worried about income loss. Up front, it's probably better to forewarned is forearmed in this situation. I think there's been some very mixed messaging coming out from different organisations, particularly on the tenant side, be it Generation Rent, Shelter, and from some opposition politicians, particularly the Labour Party. But tenants are not automatically entitled to a rent holiday. Tenants who can afford.
It looks like John's mic's gone offline, so I think perhaps if we just wait a bit.
Hello?
John, you're back again. Okay. Can you carry on from when we last spoke?
Okay, we'll go back to the start of the rent section. I'm wondering if maybe I'm experiencing some internet problems.
Yes, it may be.
Yeah. We're such a good run as well.
Yeah, never mind. Carry on, and I'll put a note. I've got a Word document that I can put on the screen there saying that we can't hear you. So
yeah.
I'll stick that up every now and again if you go offline, so you know, so you don't continue with the presentation until we have contact again. I'm very sorry about this, people. I suspect that there's broadband problems because a lot of more people are using the internet than is normal at this time.
Yeah.
So carry on, John.
Okay, well, we'll go into the rent situation. As I say, I think it's important that landlords are proactive. Forewarned is forearmed. Speak to your tenants, find out, if they are worried about their job, if, they're expecting to face redundancy or the like. We do need to be clear that tenants are not automatically entitled to a rent holiday. Generation Rent, Shelter and the like, and some opposition politicians have been given the impression that all tenants are entitled to 3 months rent-free. That is most certainly not the case. Tenants who can afford to pay their rent should continue to pay rent as normal. For other tenants, it might be there might be a need to negotiate either a reduced rent if their income has dipped, or if their income has stopped, perhaps rent-free period. But we do need to be clear that arrears will continue to accrue over that time unless you agree otherwise with the tenant. It may be you are in a position to allow a reduced rent for a period without that building up as arrears. On the other hand, you may want arrears to accrue, but at the end of the period, if the tenant's able to start paying again, if they've been good tenants, you can then write off the arrears at that period. But, there is no automatic entitlement to a rent-free period. And I think we need to be clear about that. And we have asked the government to be absolutely clear about that in their messaging. You will need to carefully document all rental payments and arrears. The government has talked about introducing a pre-action protocol for possession claims, and that does require landlords to have informed tenants about arrears and a record of payments and the like. So it's probably best to document any payments that do come in, any arrears that have accrued, when they've accrued, and the like. It's just good business practice anyway, but do make sure you're documenting that and informing the tenant about it. Don't tell the tenant every week the arrears are not going to change from week to week, but perhaps on a monthly basis, depending on the level of rent that's been payable. Consider a payment plan for arrears when the tenant is back on their feet. And of course, you may have a guarantor who'd be able to step in and help with the rental payment, or your rent guarantee insurance may cover you, but you will need to check with the insurers. And on that note, actually, we have seen that many providers of rent guarantee insurance are not issuing new insurance policies at the moment, not surprisingly.
Yeah, I've seen that as well.
Unfortunately. It's not just rent arrears per se. There are going to be some issues with the tenancy. We're seeing a lot of this, particularly with airline staff and in university towns and cities. Tenants are either asking or just simply have ended the tenancy early. You can enforce the tenancy term, but this can be difficult, particularly if you're dealing with overseas students. You can still put in a money claim if you have to. you are probably going to find it very difficult to re-let, particularly if it's been a student let. So if you can, it's probably best to try and work with the tenant to keep them in the property. Again, even at a reduced rent, it's probably better to have some money coming in than none. You will be able to retain deposits to cover some of that missing rent ultimately, and you might be able to pursue a guarantor if there is one. And in student lets, you generally will have a guarantor in place. The other issue we're seeing is the opposite of tenants moving out early. We're seeing situations where tenants have agreed tenancies but are not now moving in for whatever reason. Unfortunately, if a tenant hasn't taken the keys and hasn't moved into the property, there's not a huge amount to be done in this instance. We see that through the courts in the past. You may be able to retain any deposits that have been paid, be that a holding deposit or potentially a security deposit, but it is a very, very difficult situation that is going to leave landlords again with void properties, lost income, and other liabilities. But we are seeing a number of instances where tenants have agreed a tenancy but are not moving into the property.
Mm-hmm.
There is support for tenants. If your tenant is in employment, then employers can access grants for up to 80% of their wage, up to a maximum of £2,500. That's only available if the employer is not making the employee redundant. So if they are retaining the employee even though there's no work for them. That scheme is now open. There's detail up on the government website. First payments are expected towards the end of April. So for some businesses, this might not be enough. They are going to have outgoings they're going to have to meet. So some staff, while this might look like the solution, some businesses simply might not be able to last out to the end of April. There are government loans and grants potentially available, but the key here is getting money flowing and money flowing quickly, and it may not flow quickly enough for some employers. It is expected to apply to 0 hours contracts, but there is no similar support at the moment for self-employed. I think the government realised that this has been a major mistake. There appears to be movement and discussions within government. We may see an announcement on support for the self-employed this week. For the self-employed at the moment, it's statutory sick pay, and likewise for ill employees will be on statutory sick pay. There's been some changes. This can be paid from day one rather than the 4th day of illness, and it is reclaimable by the employer in some circumstances. In terms of welfare and benefits for tenants who have lost their job, they should apply for benefits. You should be signposting them to government websites, DWP. They will need to claim universal credit or working tax credits. Those limits have been increased by approximately £1,000 annually for 1 year. There is still the 5-week wait for a universal credit payment. That is very disappointing. They may be rate payable in advance, a repayable advance available rather, but that will be paid back from a reduced benefit payment later on, which again can split up trouble for folk further down the line. There's no change to the direct payment of the housing element to the tenant. We've been pushing really hard for the default position for new claims to be payment to the landlord. That will ensure that landlords have some income coming in. It will ensure that tenants don't build up large arrears. And particularly with the messaging coming out that tenants have a rental holiday, then some tenants might feel they're entitled to keep the housing element when they're not. Self-employed people, as said, are entitled to universal credit at the statutory sick pay rate, which is £94.25 a week. For all tenants who are facing difficulty with their rent, local councils have had funding available, emergency funding available for discretionary housing payments. That's where there is a gap between benefit payments and the rental. A lot of folk will be in that position. Folk will have been paying market rents, and the local housing allowance is paid at the 30th percentile at the moment. So there are going to be gaps there, and discretionary housing payment is there to meet those gaps, but it is discretionary. It's not automatic. People will need to apply, and they will probably target that support at families and others in desperate need initially. And there's a whole issue around about non-UK or EU nationals who will not be entitled to benefits at all.
John, there is a service, credit unions and the Tasker payment service, where you can arrange for the payments to be paid to the service, and it's sort of like a jam jar account. Is that something people should be looking at?
It is something certainly that people could investigate, but again, it will take time to set up. Credit unions have traditionally worked on quite a lot of face-to-face contacts, so it may be that they're maybe not got the online systems in place that tenants would need to do that, but it's certainly worth investigating.
Yeah, it's the Tasker payment service. If you do a search on that on the internet, you should bring it up.
That's good advice. Thanks, Tessa. There may be other help available out there for tenants with utility bills. Tenants should contact their supplier, particularly if they're on prepayment meters and the like. Suppliers have said that they will be making concessions around about that. Again, council tax, contact local authority. Have again received emergency funding from the government to support people with council tax payments. There will be hardship funds, grants and loans available. Some trades and professions have specialist funds only available to folk from that profession. There will be local and national charities for people, but obviously there's going to be a huge amount of pressure on this sort of funding, and also with less money available, actually the amount of money able to be raised by these organisations is going to drop as well. And then of course there's getting into alternative employment if possible. We're seeing an uplift in supermarkets and delivery firms hiring people now. So, there are alternative employment opportunities out there. It's maybe not going to be at the same rate that people were on before, but it is income. It will help support folk.
I suspect in due course there will also be jobs for things like picking fruit, so that we can all continue to have...
The food supply chain, of course, potentially was already facing quite a loss of staff from...
Yeah.
So there's likely to be opportunities. There are more opportunities now than before. Yeah,
and that will probably be what's the word? An employment that is essential. So
absolutely, yeah. We're going to have to keep food on the shelves. And a lot of it is not necessarily overly specialised work. Even when I was a kid, even I did a bit of tatty picking for the New Ayrshire potatoes in my time.
Yeah. Okay.
Support for landlords. Unfortunately, there is not a lot of support out there at the moment. The main support that the government has negotiated with UK Finance is the mortgage holiday. Of course, it's not a holiday. It's either a deferral of interest payments, a deferral of all payments, but those payments will accrue either onto the end of the loan term or through increased repayments, monthly repayments once the holiday is over. The good news is that most lenders are not requiring much in the way of evidence to access this holiday. Is applying to company lets as well as to individual borrowing, and it should not affect landlords' credit rating. But you will need to contact your lender and discuss the options with your lender. Other support for landlords, this is very limited. Obviously, if you have taken out insurance or have a guarantor, that is somewhere you can turn. It's unclear if the council tax support for tenants will apply to landlords and HMOs. That's something we're pressing the government on. There's no indication of further government support at the moment as to whether the self-employed support will apply to landlords, whether any of the grants or loan systems out there will be available to landlords. The suspicion is that they won't be, but we are aware that landlords do have outgoings in terms of agent payments, in terms of bills, in terms of maintenance, insurance, licensing fees. We are flagging that up to government. We are saying that, perhaps things like a break in council tax, particularly where a landlord has ended up with a void in their property, and the council tax liability has fallen back on them. It would be a good time for councils to consider a council tax break, perhaps for 3 months, just to support landlords through that period. So there's not a lot of support there out there at the moment. We are taking concerns back to government and pressing government on that.
Yes, I suppose the problem is that this crisis isn't going to end after 3 months. So at the end of that 3-month period, we'll still be in the same situation.
Yeah, it's clear there's going to have to be some sort of long-term support, and at the moment what we're getting is fairly piecemeal. We had some support in the budget and then an emergency statement from the Chancellor a week later, and now it looks like we're going to get another emergency statement to deal with issues around about self-employed, and I suspect that we are not going to see much in the way of action in terms of supporting rents and payments to landlords until we start seeing people threatened with homelessness. And at that point, we might see tougher eviction prevention measures from the government, but there may be, at that point, they have to look at more support in order to help people stay in their homes.
Mm-hmm. Okay.
But it's not a happy picture at the moment, unfortunately.
Well, it's not a happy picture anywhere, yeah. So landlords are not unique with that.
Yeah, we are all going to have to share in the pain, unfortunately. Okay, we'll look at the possession restrictions. I had expected this to be a huge, long session, given what the government had said last week, but there appears to have been some changes behind the scenes, and the possession restrictions at the moment are rather limited. The bottom line is there's emergency legislation in the coronavirus bill, which is effectively introducing a 3-month notice period for most possession claims. However, it doesn't appear to apply to licenses and company lets, some agricultural lets, so they will proceed as before. And we've not seen pre-action protocol requirements be brought in yet. That's where, the landlords would have to prove they'd taken certain actions in terms of informing the tenant about levels of arrears, supporting them with benefit claims and the like. When the possession claim reaches court, we've not seen that introduced yet. However, bear in mind that the court's already acting to limit and suspend hearings on possession. Bailiff availability is being affected by work and travel restrictions, self-isolations and the like, and some courts are taking it into their own hand not to order bailiff action. And also ministers will have wide powers from the coronavirus bill to extend or vary legislation. So this 3-month notice period at the moment could be extended, for example, to a 6-month period if, as Tessa says, the situation will persist. At that point, we're going to need to see changes to the Section 21 legislation because there's a 6-month use it or lose it from service. And if you have to give 6 months notice, it'll be almost impossible. It won't be almost impossible. It will be impossible to successfully implement a Section 21 notice. So the news is not quite as draconian here as the government had suggested it would be last week, but there are powers reserved to ministers to change and vary legislation. And if we see a glut of landlord evictions, for example, if there's a stampede to serve notices this week, where the notice period is still only 2 months, I suspect that we will see other legislation. We've already seen it where people have ignored social distancing rules. That led to last night's announcement by the Prime Minister. So if landlords ignore the government's request to be sympathetic to the tenants, to try and keep people in their homes for as long as possible, people are ignoring that advice and rushing to evict, then we will almost certainly see tougher legislation. People do need to be compassionate and they do need to be sensible.
Just sort of thinking, John, so far as rent repayment insurance is concerned, you need to have a look at your policy and see what it says. But it may be that if you serve a notice but are then unable to do anything else, that may qualify you under your rent repayment.
Yeah, when the government was talking about an out-and-out eviction ban and preventing landlords from serving notices over this period, we did raise the issue that, in order to access insurance policies, landlords quite often have to prove that they've served notice. They are taking steps to suspend the tenancy so that the arrears don't simply run on and get out of control. So we have made that point to government, but people do need to check the terms of their insurance and act accordingly. And unfortunately, some insurances require landlords to serve notice.
And so far as the limitation periods for the use it or lose it time period for Section 21, I would suggest landlords keep a detailed note of when they've served it and then diarise it for 2 or 3 months before the period is due to expire, and then serve another one.
Potentially, yes, and also keep a note of the steps you've taken to support or help your tenant over that period, and make sure you are perhaps updating your tenant monthly with a statement of account, effectively, with rent paid and any arrears outstanding. Make a note if you have signposted them to DWP, Universal Credit Claims. Of course, the pre-action protocol that might appear is written for social housing, who have much better access to information on the tenant's benefit situation like the private landlords are entitled to. So it's unlikely the protocol could be very sensibly applied in its current form.
Well, they did say that that they are going to amend it. I did see that. So it will be an amended version. It won't be exactly the same as the pre-action protocol that applies to social landlords.
Yeah, and absolutely, we do. It does need to be different. The two forms of housing aren't the same. They don't have the same expertise. They don't have the same access to staff and specialist knowledge, and they don't have the same access to information.
So I think probably landlords and agents, you need to record absolutely everything. I have to say I tend to use the Google documents and Google Sheets quite a lot. That's quite a good way to record things, and then you can share those with people as well. You can also use Dropbox, so that there are lots of ways that you can keep a record, but just keep a record of everything you do so you can prove later what happened.
Yeah,
record what you said. Record what you discussed, what you agreed, what you thought, why you came to that decision. Don't just say, I decided this. Say why. Yeah,
give reasons. And some of the record keeping should be second nature to landlords now, because it is such a document or evidence-driven sector, whether it's proving you've given your gas safety certificate or, the prescribed information and etc. It's very document driven, very evidence driven now. Records are important.
John, shall we go through some of the questions now?
Yep, that would be great.
Okay, well, I'll sort of start from the bottom and move up. Question from Nick. I have a notice of issue. The tenant hasn't submitted a defence. I have 6 months to apply for a possession order. What should I do? I suppose you can submit, but you may find that the court won't process it.
Yeah, that's the current situation. I would suggest in those circumstances, if the tenancy isn't rescuable, then you are simply going to have to submit, but be prepared for delays in court, and be prepared for some tough questions when you do eventually get to court.
I've had a question for Gareth. I've served 2 notices a couple of months ago. One was a Section 21, the other was a Section 8 due to rent arrears. I had a court date on the 21st of April, which I assume will have been cancelled. Well, you need to check that, Gareth, so I should be in touch with the court. After the freeze, do I still need to abide by the new pre-action protocols, more designed for social housing sector, which is far more onerous? Well, we don't know. So I think the thing to do is just to watch this space. They've just said that they're going to apply the pre-action protocol. They haven't actually applied it yet. So we'll just have to see what happens with that.
Yeah, and that's good advice across all hearings. Well, the courts are no longer meeting in person, and they're no longer booking possession cases and like that. It's not that they are not meeting at all. They are trying to move to online structures and the like. So you do need to still check, if you have a hearing date, check whether that hearing is going ahead and how it's going ahead.
And maybe a good way to contact the court is by email. And I would say that if you do contact the court by email, it is absolutely essential that you cite in your correspondence, probably in the subject line, the case number, because if you don't give them the case number, they won't be able to locate your case or get back to you properly. So it's really important that every communication you have with the court, you put your case number.
Yeah.
Right. Nick says, I would have reduced the number of occupants to 4 to remove the need for a licence, but now this isn't possible. Will the local authority issue a temporary licence until I can evict?
This is a difficult one. I mean, it's like a temporary exemption notice that you'd apply for, but they only last for 3 months and you can only ever get 2. So
maybe keep quiet about it for the moment. Maybe you're not aware, Nick, that there are more there. I suppose the trouble is, if you talk about it to the council, I think probably wait and see, really.
Yeah. And this is just those areas that we're trying to flag up to government.
Yeah, I mean that's something that you can take note of these things, John, and use it in your discussions. Yeah. Nicola has said, will student loans continue to be paid out?
Well, we assume so. I can't see any reason why they wouldn't at this point. It's important that people have income coming in. Loans shouldn't be dependent on unilateral decisions by universities to close down. And the government per se that's closed down teaching. Some are moving to online teaching and the like. So yeah, I would anticipate student loans.
Emma says that she has 2 lodgers. Are lodgers entitled to rent holidays? Their rent makes it possible for me to live in my house. I'm concerned if they don't pay their rent, I will not be able to afford to live in my house. And will be subsidising the living costs of 2 other people. Well, the trouble is, all this legislation and all the things we've been talking about are really to do with tenancies. Mm-hmm. Lodgers are different. They have a residential licence.
And they are not included in the 3-month notice period. So if you wanted to evict a lodger, it's as you were. It's a notice to quit with reasonable notice. But again, to reiterate, no tenant is entitled to a rent holiday. Where a tenant can afford to pay the rent, they should continue doing that. So if they are continuing in work or continuing to claim benefits, nothing's really changed for those tenants. They should be paying the rent, or if they're not working but being retained under the government's workforce retention scheme, then again, you may want to consider a reduced rent, but they will still have income coming in. They are still expected to meet the costs.
Okay. Sorry, I've lost my place with this. Let me just go down again. With lodgers, we do have, I have a free website for lodgers, which is Lodger Landlord website, which sort of sets out the law as I understand it relates to lodgers. So far as I'm aware, that is still the same. So you may want to consult that about the legal situation for lodgers. We've had quite a few questions about whether people can use the deposit towards the rent now. Can we ask deposits to be released to the landlord as rent rather than keeping it until the end of the tenancy? What's the situation on that, John?
No, the deposit comes into play at the end of the tenancy. So, if the tenant has surrendered the tenancy and you have evidence of that, then yes, potentially. But if the tenant has just upped and left and the tenancy has a period to run, unfortunately, it's a case of waiting until the end date of the fixed term or the period, if it's a periodic tenancy, and then making an application to the deposit scheme. But you will need evidence that the tenant has effectively abandoned the property.
I think what people are thinking is, we are halfway through a fixed term of a year. Can we get the scheme to pay the money to be now so that we have the money now rather than at the end of the fixed term?
Yeah,
the scheme pay that out if the tenant agrees with it.
If the tenant agrees, that may be a different case. But effectively, we need to demonstrate the tenancy had ended. whether that's through abandonment or surrender. But it's a discussion with the tenancy deposit schemes.
I think you need to speak to the tenancy deposit schemes. I mean, I think there's a difference between when the tenancy ended, but a lot of people are saying, can they have it now when the tenancy is continuing?
Yeah.
So that they get deposit money now rather than at the end of the tenancy. I think that you probably need to speak to the schemes about that.
And I think this, just to be aware, I think the schemes will have limited flexibility because the schemes are statutory. They're set up by law and will, for the time being, have to follow the legal process.
So you need to look at the terms and conditions of the scheme and have a word with them. Anna says, can landlords hold students who wish to terminate early to pay the full rent, especially if the parents are guarantors?
Technically, yes, you can.
Yeah, you can.
And I suspect in the current climate, ordinarily, if they ended up in court for a money claim or the like, it would be a case, well, how long would it take you to reasonably fill that property? You know, if there's 6 months to go, it's unlikely you're going to be able to claim 6 months rent ordinarily because you're probably going to fill that property in 1, 2, 3 months' time. However, in the current climate, that property may well be empty for 6 months.
I think under the tenant fees legislation, it was that you can claim the cost of reletting the property and rent in lieu up to when the tenancy actually changes over. But the total amount that you claim can't be more than the rent that they would have had to have paid under the tenancy agreement that they signed.
Yeah.
But I mean, the trouble is you can't get blood out of a stone. If people haven't actually got the money, even if you've got a cast iron legal justification for claiming it, you're not going to get it because they haven't got it.
Yeah, that's just the realistic situation for some
people. You know, you just have to accept that, and sometimes we can't get what we're legally entitled for. This is you know, it's not just a national crisis, it's an international crisis, and we can't really all expect to get what we're entitled to. Jacqueline says students have gone home, property empty. Can landlords still insist on having rent as there's no break clause in the tenancy? Well, technically you can.
But again, you know, how practical is it, as you say, if tenants have lost income, then the chances of claiming that through a money claim or whatever is probably slim. And this is where, you know, it's best to try and work with the tenants and basically get what you can without the time and cost of legal action.
Legal action is going to be very difficult for quite a long period of time. So I wouldn't, I mean, there's the problem of actually getting the judgment in the first place, and the courts, you know, half their staff are probably self-isolating. It's going to be difficult for them to process the paperwork, and then if you actually get a judgment, then there's the problem of enforcing it, which is also very difficult. So I think people ought to try and agree things with tenants rather than rely on their strict legal rights, because it's going to be difficult for them to enforce it.
Yeah, absolutely.
Helen has said, I see MHCLG have issued guidance this morning that house moves should not take place. What do we do if we have confirmed changeovers happening in the next 3 weeks?
Right. That is something that I haven't quite get up to speed on, because I've been on the webinar here. We had rather assumed that you know, people moving house would be essential. I mean, this creates all sorts of problems potentially. Either you're leaving people homeless if they can't stay in the property they have been in. Again, it's potentially leaving voids for landlords if people just up and move out at the end of their term and landlords can't re-let. And this is just typical, unfortunately, of the government piecemeal advice. That's something I will have to go off and investigate. We will get advice up on our websites as quickly as we can.
I've got quite a long question from Jackie, who says, we have a rental property that's becoming vacant on the 31st of March. We have a new tenant interested in taking on the property. We are aware of the current restrictions and are adhering to them. How do we go about doing the vacating property check so the deposit can be returned to the tenant? And how do we show the new tenant round the property? If we are unable to do the above, the current tenant will not be able to have their deposit back. Are we legally allowed to hang on to it until the final inspection has been done? And are we at risk of having a property void if we can take on a new tenant. We have a decorator lined up to redecorate, but again, is this allowed to take place? He will be working on his own.
Again, it's a bit of watch this space, particularly if there is new guidance out from MHCLG. The deposit schemes have rules in place over how quickly a dispute has to be raised and how quickly a deposit has to be paid out. We really are all really swimming through treacle at the moment with some of this. It's almost impossible to cover and legislate for every single scenario that's going to come up. It's why that the government needs to move more quickly to issue clear guidance. It was apparent that people's homes are crucial, that the rental sector is crucial, and they're really very disappointed that they haven't taken the housing aspect more seriously and haven't moved to be clearer and issue clear guidance and put proper support in place for people who are still facing costs or losing income.
My feeling for Jackie's question, and I haven't got any sort of legal backup for this, but my feeling is that you really need to do what is practical for the situation. If you've got people who want to move out and you've got someone who wants to come in, then really that probably should happen, because there's no point in keeping people stuck in a property that they don't want and preventing people from coming in who want to do that. So then you need to think practically, how can you deal with the changeover? Just off the cuff thoughts, maybe if they move out and then once they're out of the property, perhaps keeping social distancing, you do a checkout meeting then, and then see what the situation is about getting it cleaned and decorated. If that's not possible, then you'll need to talk to the incoming tenant and explain to them that that's not possible, and are they willing to take it as it is? I suspect they will be if they want the property. Maybe give them an initial reduction, a credit on the initial rent to take account of that.
Yeah, we are going to have to try and be imaginative, I suspect, over situations like this. Is it possible for the outgoing tenant to, compile a list, a video, whatever, of the property and the issues that they've identified, and then vacate the property, have the landlord or the inventory clerk go in, or the agent, and do the same, compare notes, and then deal with deposit issues. I think issues round about is decorating an essential service at this point? Probably not. It might be something that, as you say, you have to have a discussion with the incoming tenant about. We are going to have to find ways of working around this. If the government isn't going to give absolute clear guidance in terms of banning this, that, or the next thing, then we have to be practical and use common sense while sticking to the basic guidance on hygiene, social isolation, etc.
Yeah, we've got a question from Elena, whose tenant is an Uber driver and says he can't pay the rent. She's concerned about her mortgage. She understands that he can pause his payments but will have to pay in the end. But what does she do if he ups and leaves to Poland? Well, I mean, with the air lockdown, he may find that difficult. But I think you just have to deal with things as they arise.
Yeah. I think that the issue here is not that any of these situations are new per se. There's always been a danger of a tenant abandoning a property, of leaving rent arrears, etc. I mean, these are risks that landlords take on. The difference is that one, it's happening to lots of people, and two, the ways you would normally deal with that aren't necessarily viable or accessible just now. And that's a real issue. Can you progress a possession claim? Are insurers going to abide by policies, or is there a clause stuck in there that says global pandemic, we are not paying? All these sorts of issues. So they're not new problems. It's things that landlords have always faced. It's just the environment that they're happening in is extreme.
I would suggest that you get hold of all your insurance and have a read through the terms and conditions so you know what you're facing. That would probably be, because it may be that there may be things that you can claim. So do have have a look at that. I've had a question for Becky, who's got an EPC certificate and gas safety certificate due. Should she be deferring? Again, as I said earlier, Becky, I think you ought to, if you can get the tenant to say that they will not allow access, then that gives you a reasonable excuse not to do it.
Yeah, or if you can get contractors to say we're not coming in.
Yeah.
Again, that's but it is a very difficult situation, and these are common situations. And I just say it again: we should be getting clear guidance, and we're not, and we will continue to press the government. For what I keep saying, it's homes are crucial. They're crucial to obeying the government's guidance on health. They are crucial for people's health and well-being. 1 in 5 people live in the private rented sector, and we're not getting the clear advice and support you would expect 3 or 4 weeks into what an crisis.
We've had a question from Julia about zero deposit schemes. And she says, does zero deposit allow self-managing landlords who don't want to go on with an agent give existing tenants their deposit back if they qualify for insurance? I think probably with the zero deposit schemes, I don't know what you think, John, is that they are all different. Unlike the traditional deposits, where they're regulated by the government and there's strict limits on what they can do, zero deposit schemes are all different.
They're very much commercial entities or commercial offerings.
They're not regulated in the same way. So you really need to look to the scheme and see what it says.
Yeah.
I don't think we can really advise on those because we don't know what their terms and conditions are.
Yeah. And it's such a new area as well. What will apply with one scheme won't apply with another. And a lot of them actually leave if the landlord gets a payment, leaves a liability with the tenant, and again at the moment, an insurance company trying to chase a tenant through the court payments is likely to have as much success as a landlord.
We've had a question from Sandra, who says we have a builder due to go into a property to install 5 fire safety changes required by the council. This is an HMO. Are we allowed to continue with this? Well, I suppose so long as you can do it within the safety guidelines.
Yeah, I think fire safety, particularly in the current climate, is one of those things that I think has to be done. If it's complying with HMO guidance, it's for the safety of your tenant.
I think you're rattling paper in front of the microphone.
No, it's a cat.
Okay, can you move the cat?
Yeah, she's been evicted.
Okay, right.
I think in terms of fire safety, particularly in the current climate, is so essential. It is about tenant safety. It's not just about meeting your HMO obligations. It is about the safety of the tenants. It's there for a good reason. I think that is work that will need to be undertaken, but undertaken within the confines that we've discussed already: hygiene, social isolation, staying away from the tenants.
Okay, so go ahead if you can, Sandra, but do the best you can within the limits that we've been told. Julia asked if there's any movement on the housing court. I think probably no.
Yeah, there's no movement in the housing court despite before the coronavirus situation. Unfortunately, we're 18 months, I think, after the government's consultation was launched, and we've still not had a response. And I imagine now all energy in government's going to be looking at addressing the issues around about coronavirus. So I suspect the housing court, the renters reform bill, and the like are going to have to take a little bit of a back seat for now.
I would mention, though, that there were committees and things that were looking about online courts and changing the way that the courts work to have more virtual courts. And it may be that I suspect that those plans will be accelerated, and those will affect housing claims as well as any other. And it may be as part of that they may decide to siphon out the housing actions and have them dealt with slightly different. I don't know. In the strange situation that we find ourselves in, we're going to have to find new and different ways of doing all sorts of things, and the courts are no exception to that.
Yeah, we're already seeing emergency legislation to allow evidence and hearings by video and the like. That is part of the coronavirus bill that's going through Parliament at the moment. So yeah, we are going to see changes that perhaps would have been introduced in a longer term, more planned fashion happening more quickly.
Okay. We've had a question about the slides. Again, if I could just say again that the slides, you can download them. There should be a handouts link somewhere on your panel, and you should be able to download the slides. I will also put the slides up in various places on the Landlord Law blog, on my Landlord Law site. John, you'll be able to load them up on your sites so people can download them. And of course, this webinar is being recorded, and people will be able to listen to it again.
Can we edit out the cat?
Sorry?
Can we edit out the cat?
Well, that is slight relief. Maybe you ought to take a photograph of the cat and put it online as well.
Yeah.
We've had a question from Terry, who says, where a student rent includes an element for utility bills, can the student reasonably request a reduction in rent relating to the utility cost if they've already vacated the property?
Of course, they can reasonably request anything. It's really up to the landlord how they respond to that. If they've vacated the property and there are rent arrears, you would be, if you were looking at reducing the utility element, the all-inclusive element, then you obviously be reducing the overall arrears that were due, which, as we've discussed earlier, might be sensible in a situation where recovering income through the courts or through legal action is unlikely, even with a successful judgment. The ability of people to pay and the ability to enforce that judgment is crucial. So, any negotiation that you can have with a tenant that brings income in, where otherwise there would be no income and you would have to resort to legal action, I'd strongly recommend that you take.
Yes, I mean the enforcement, generally the enforcement procedures for county court judgments. I mean, I think if people have been sitting down and working out the most awkward and difficult way to enforce county court judgments, they couldn't really do any better than the system we have at the moment. It's rooted in the 19th century and it's very inefficient.
Yeah, I mean the deterrent is in the judgment itself.
Yes, but if you've got people who don't care about judgments, you're in a difficult position. The main thing is if you've got someone who doesn't want to have a judgment because it affects their ability to get a loan and a mortgage.
Yeah.
So that's where choice of tenant comes in. But of course we're beyond that now, really. Yeah. I think we've answered most of the questions, John. Do you have any final comments?
Just that it is a hugely difficult time. Landlords were never the most popular of people before we came into this crisis. As a sector, we are being watched and our actions will matter. And it's been really pleasing to see tenants posting stories about how good the landlord has been, how flexible, what help and support landlords have been offering. But unfortunately, there is the flip side to that. We have seen stories about landlords looking to evict NHS frontline staff or refusing properties to NHS staff because of fears of getting the virus. Now, you are going to be relying on those staff if you fall ill. So, don't be stupid about these things. Don't create unnecessary negative headlines if you can avoid it, because these things will find their way into the media. It will further tar the sector, and it will mean that future legislation like the Renters Reform Bill may be an awful lot worse than perhaps anticipated. I know times are hard for everyone at the moment. I know some landlords are relying on the income from the property, but that loss of income was always a risk. At any time, tenants' circumstances can change and can fall into arrears. Just at this time, it is affecting so many people. We are all going to have to shoulder some of the burden of this. So please don't make things any worse by reactionary, stupid or negative actions if you can avoid it.
Yes, because the government will be reacting to what the stories that they see in the media.
Yeah, and we've seen that. We've seen that across other areas. You know, we've seen it in terms of the restrictions. It was, please don't go to pubs, but we're not shutting pubs. And then when everybody went to pubs, it's
Yeah.
okay, we're shutting pubs, but please practice social distancing. And then when people didn't practice social distancing, it's okay, we're shutting nearly everything. And you know, if there's a rush of Section 21 notices towards the end of this week because things are going to change on Friday, then the government will take tougher action and tougher steps, and we'll all suffer from the actions of a selfish few.
Yeah. Okay, right. Well, that's the final slide, which has some details of the websites, our various websites, the Residential Landlords, the National Landlords Association. The Residential Landlords Association has a superb collection of information pages for landlords, which I would recommend you go and look at. We have stuff on landlord law as well. And as I said, of course, you can listen again to this webinar. It will be loaded up and it will be available to everyone. And if you are interested in our virtual conference in May, goodness knows where we'll be then, but that is planned to go ahead. Let's just have a quick look and see if any more questions have come in. Alina asked where we can access the recording. I will be putting it on the Landlord Law blog and on the Landlord Law website. And John, will you be putting it on the National Residential Landlord Association sites?
Yeah, we will get the recording up on our websites as well. Yeah, once I figure out how to download it myself.
Okay. Right. Well, I think that's probably all, is it, John? Shall I close down?
Yeah, no, thank you very much for facilitating this, Tessa. I think technical difficulties notwithstanding, I think it's really important that we get information out there, that we're as honest as we can be with people. We're all flying a little bit blind. We're all trying to apply common sense. So it's good to have the opportunity to discuss with you, answer the questions that have come in, and make sure that people are aware of the resources that are available.
Yeah, and maybe we'll be able to do another one in a few weeks' time when we know a bit more where we are and what's happening.
Yeah.
Okay, right. Well, thank you, everybody. I will now close the webinar down.